she's not going anywhere. They're going to send her right out.
I'm going to ask her.
Go ahead, do it.
That's fine.
I don't get to make those decisions unilaterally.
Putting 180 days in the state jail in lieu, with everybody's agreement,
No objection, yeah.
in lieu of confinement in the county jail. Desiree Boyce.
Yes.
Oh, you're wearing different glasses today. Or you find something different? It's a different, it's a look. It's a great look, Kathy. It's a great look. Makes you look like a professor, actually. In fact, I'd like you to test two of these lawyers here. Give them an easy test and see how they do.
I didn't get a chance to study, Judge.
They all say that.
You gotta do the rest. One and three. One. Either one or three.
Are we working off of a second amended motion to revoke probation? Is that
That's fine.
where we are on this? Okay. Because I've got it, but
That's my
I didn't know if
understanding.
that was the most recent one.
That's my understanding as well, Judge.
Wow. This,
Pleading to allegations. Very good.
not 18, but 19 violations here. I've done this a long time. I've never seen a motion with that many. But that does not scare me.
Yeah, it's, you know.
18-30652 is called the State of Texas versus Desiree Monique Boyce. Is that you?
Yes, sir.
Present with your attorney, Mr. Turner, the state's attorney, and the probation office is here. There is a second amended motion to revoke probation that has been filed. Shoot, that was filed over a year ago. That's what we're going to be working on. Do you understand?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Does the defendant waive a formal reading of this second amended motion to revoke probation? Can we proceed in summary?
Yes, Judge.
In summary, ma'am, this second amended motion to revoke probation in this cause number 18-30652 alleges that on August 26th, 2019, well, going on 7 years ago, in this Criminal District Court of Jefferson County, Texas, you were sentenced to 5 years in prison. That was suspended for 10 years probation for the state jail felony of unauthorized use of a motor vehicle. And it was a state jail felony, but it was punished. It looks punished as though it were a third-degree felony, because you had two prior state jail felony thefts in 2018, an unauthorized use of a motor vehicle, and a state jail felony of theft were the two prior convictions out of Bayard County that were used to bump the punishment range up from what would have otherwise been a state jail felony, as it is in this case, but it is punished as though it were a third-degree felony, and you were looking at up to 10 years imprisonment. Is all of that true and correct?
Yes, sir.
We're not going to do all of these. Just give me the bullet points. Which one's she going to plead to?
1 and 3. And the state would abandon the remainder, Judge.
The judge actually says it himself at the start. He's never seen a motion with 19 alleged violations on it. But by the time this hearing actually happens, it's been narrowed way down to just 2. A positive drug test and missed drug screenings. That's pretty normal in these cases. Prosecutors list everything on paper, then negotiate down to what they can actually prove and what's worth pursuing.
I'm sorry, it's 1 and what?
3.
Was a lot of effort that was put in here because, I mean, this is 1 and 3 were 2 amended motions ago. Were already in there. We could have moved this thing a long time ago.
We have to go.
All right. 1 states you provided a urine sample on or about March 5th, 2021 in Bayard County which showed the presence of marijuana in your system, which is a violation of condition 10 of your probation order. And get into it. Looking for the probation order. There it is. On the right side. Probation number 10. Order that the court signed when we placed you on probation. Do not use or possess any drug. Use of, possession of, and prescriptions of any and all medications must immediately be disclosed to your probation officer. Is allegation 1 true and correct as it is alleged?
No.
Yes, sir.
You're pleading true to that
Yes, sir.
voluntarily and because it is true.
Yes, sir.
Number 3 states you failed to submit to alcohol and or drug screening on or about November 23rd, December 21st of 2020, March 3rd, April 9th, 2021, at the direction of Bayard County Probation Office, which is a violation of condition 25 of your probation order, which is submit to alcohol and or drug screening at the direction of the probation office. Is that allegation 3 true and correct as it is alleged?
Yes, sir.
And are you pleading true and correctly this as well as allegation 1
Yes, sir.
voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntarily and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation, such as the second amended motion to revoke probation? Your probation can now be revoked, and you can be sentenced to no less than 2, no more than 5 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes.
I'm looking at an agreement that has been reached in your case where your probation would be revoked.
It's still in jail. It's still in state jail. Yeah. So
It's a state jail.
yeah. So
And this is showing 180 days in the county jail. It's got to be 180 days in the state jail, right?
And I tell you, the thinking behind it, Judge, is we want to punish it under 1244 of the penal code as a misdemeanor.
I didn't do that.
Well, that's what we would recommend to the court, and I tell you why. She has a sufficient amount of jail credit on the county side to satisfy this.
No, hold on. I didn't do that at the outset of the crime. That's when I should have done it.
Understood.
When I said that I sentenced her to confinement in the state jail. That was at that point in time when she was sentenced was when 1244 should have arisen. It
Yes.
didn't.
This is a genuinely rare moment. The judge stops and realizes he made a technical error back when he originally sentenced her, mixing up state jail confinement with county jail. He catches it himself, works out loud through how to fix it, and lands on 180 days in state jail instead. It's a good look at a judge holding himself to the same accuracy he expects from everyone else in the room.
But I mean, you got no less than 180 days up to 2 years in the state jail.
Yeah.
I mean, that's what needs to be in there, not the county jail. I don't think I have the authority to do that. But what do you want me to do? Change this to 180 days in the state jail? She's going to be given credit for all time she has served, whatever that is. Do you know how much?
Over 400 days.
She's got over 400 days. So she's not going anywhere. They're going to send her right out.
I'm going to ask her.
Go ahead, do it.
That's fine.
I don't get to make those decisions unilaterally.
Putting 180 days in the state jail in lieu, with everybody's agreement,
No objection, Judge.
in lieu of confinement in the county jail. Is this your understanding of the plan then?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
It's
Let me show you what's marked as State's Exhibit 1. Did you sign that?
yes, sir.
And understand it, discuss it with your attorney. Are the contents true and correct here?
Yes, sir.
States Exhibit 1 tendered into evidence.
No.
Without objection admitted. This also states if I follow this agreement, you have waived all rights of appeal. I am going to do this. Anything else to add by the parties?
No, nothing from the state,
If
Judge.
not, I'm going to find that there is sufficient evidence supporting the second amended motion to revoke probation under House number 18-30652 to grant it by preponderance of the evidence or greater as allegations 1 and 3 are proven true. And this second amended motion to revoke probation is hereby granted, and your probation is hereby revoked based upon the court's findings of these violations of probation. I'm following this agreement proposed and authorized by the parties. You are hereby sentenced to confinement in the state jail to a term of 180 days. You will be given credit for all time you have served. You understand what has happened today.
Yes, sir.
All right. Do well. Thank you.
Here's the number that actually matters. At the end of all this, she's already served over 400 days, way more than the 180-day sentence just handed down. So practically speaking, this hearing isn't sending her anywhere new. It's just formally closing out a case where the time's already been done.
What are we doing on this?
This is the one that we thought we had a plea worked out, but Ms. Edmondson has informed me that he wants to release me and his family hire a new attorney.
Okay. Where is it? Yeah. No way. You can hire, but here's what we're doing. It was, this was set for trial. It's 1,000 days old. Sorry. And it's a murder case. We're not going to wait until the last minute and try to manipulate the court.
This is a tactic judges see constantly, a defendant asking for a new attorney right when a long-scheduled trial is about to start. The judge isn't refusing to let him hire someone. He's refusing to let that request become an automatic delay. The trial's been set for 1,000 days at this point, so the message is clear. You can hire who you want, but the case moves forward either way.
This was set for a plea. That's fine. If you don't want to plead, plead. If you don't plead, that's okay. It's for trial. So we'll try this case first today. All right. That's
Judge, I was under the impression that it was going to be a plea. I need time to go and make sure my witnesses are
Yeah.
available for today.
Yeah, that's not your fault. That's manipulating that I don't like. But there are no deals. We'll try this case first. Okay, and that's what we will do. Set one, I think set number 1 at 1:30. Next is, who else has a?
There's no problem.
What is that?
Judge, Mr. Edmondson had to address the appeal in regards to his concern for us. We can't do it. Counsel. So
What's his reason?
well, he doesn't believe that I've been representing him to obtain business.
All right,
He's
we'll bring him. He wants to come out again?
interested.
All right, bring him out. Edmondson, give me that phone. I got it. Try Edmondson again.
And she's upstairs gathering up her witnesses as we speak, so another Monday.
Come on out. We're back in 23 CR 2076 Jordan Edmondson. This has been set for trial. Mr. Lewis has been in this for 2 years and then representing the defendant. And
House we can't.
his actually, it's longer than 2.5 years. We said a bunch of times. I'm going to file numerous motions. It's where they created it. And Back, and this is back in February, 6 months ago now. This case was set for a plea hearing in March. I don't know what happened on that. I guess it's not showing. I guess on March 9th, when this was set for a hearing, y'all decided it had to go to trial.
Yes.
I guess. All right. So it's been on the trial docket. Then since on or about March 9th, 4 months, and we're ready for trial. And it's a case which is it's almost 1,000 days old, and you've been on it for years. And I know Mr. Lewis prepares and does well at trials, and so period. Now, you want to get somebody, you can represent yourself if you want, but we're trying this case at 1 o'clock. You can go hire somebody, but I'm sorry, y'all have been for years.
Give me 3 days?
No, years. You've had years, 2 years, over 2 years. So we're trying this case. Y'all wanted a trial. You got a trial.
I'm
then
in the same though.
you're going to interrupt. The rules of the court. Who is that standing up? Sit down. You can't.
It's not his fault. The offer's not changing from our side. We're not changing the offer. It's staying the same.
It's been set for years, and we're going to try it. And it's a murder case, which is the most serious type of case. It moves. It becomes on the front of the line. That's the way the rules are. It's a most important type of case to trial, and we're not going to delay it. Y'all wanted a trial. You got what you want, and at the last moment, manipulating. You don't have the time we're not going to do that. He's a competent lawyer. We're going to try the case. Pick a jury at 1 o'clock. Period. That's the way it is. If I open the door for one, everybody would come. I know it's been for years. Today I've decided I don't want a trial. And everybody gets ready, and then it's a trickery. It's a game of trickery and sleight of hand. It's manipulated. You don't get to decide when the trial is. You wanted a trial, you got it. And it's going to happen at 1 o'clock. Thank you. That's all.
And that's where this one lands trial starting the same day. No more delays. Two very different cases in this video. One about a judge catching his own paperwork mistake. One about a courtroom staring down a last-minute delay tactic. If you want to see how these hearings actually play out in real time, hit subscribe and drop a comment on which case stood out to you most. We'll be back with more.